Madam Chair, we're live.
Great. Thank you so much. Okay, good morning. I'd like to call the December 5th, 2025 Commission on State Mandates meeting to order. Please bear with me. I have a little bit of housekeeping before we get started with our business for the morning. This is our hybrid meeting, so we have both folks in person and online. For those participating in person, I do have some, like I said, housekeeping information regarding the building. On the table at the back of the room are paper copies of the meeting notice and agenda, new filings, proposed consent calendar, and witness list. The electronic public hearing binder is also located there on a laptop. Please note that the room is microphoned, so speakers and microphones on all devices must stay muted for the duration of the meeting to eliminate feedback noise. When called up for an item, the parties and witnesses will please come to the table and sit at a designated laptop. The restrooms are located out the entrance door and through the door on the left. The men's restroom is located on the right, and the women's restroom is at the end of the hallway to the right. Finally, please take note of the emergency exits in the room. In the event of an emergency, please exit to the door to my left, turn left, and go down the stairs. For those participating remotely, the materials for today's meeting, including the notice, agenda, proposed consent calendar, and witness lists, are available on the Commission's website at www.csm.ca.gov under the Hearings tab. When being sworn in at the beginning of the hearing and when called for an item, the parties and witnesses will please turn on their video and unmute their microphone. At the conclusion of the item, please turn off the video and mute the microphone. In the event we experience technical difficulties or the meeting is bumped offline, we will restart and allow time for people to rejoin before recommencing the meeting. If we are unable to restart, a notice will be posted on the Commission's website listing the items to be heard at the next meeting. Please remember to speak slowly and accurately for the benefit of the court reporter and an accurate transcript of the hearing. With that, Juliana, will you please call roll?
Yes, ma'am. Member Nash notified Commission staff that she will not be able to attend this meeting. Mr. Adams.
Here.
Ms. Green Ross.
Here.
Mr. Oppenheim.
Here.
Mr. Polland.
Here.
Ms. Peralt.
Here.
Mr. Powell.
Here.
Madam, we have a quorum.
Great, thank you so much. Next is item 1. Are there any objections to or additional corrections of the September 26, 2025 minutes? Seeing none, are there any public comments on this item, either in the room or online? See none in the room.
Move to approve.
Madam Chair, there's no public comments online.
Thank you so much. Is there any questions from the members? Okay, we have a motion from Ms. Green Ross. Is there a second?
I'll second.
Second by Mr. Oppenheim. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Green Ross.
Aye.
Mr. Oppenheim.
Aye.
Mr. Polland.
Abstain.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
Great, that motion carries. Now we'll go ahead and move on to our next item, which is public comment.
Public comment for matters not on the agenda. Please note that the Commission may not take action on items not on the agenda. However, it may schedule issues raised by the public for consideration at future meetings. We invite the public to comment on matters that are on the agenda as they are taken up.
Thank you so much. With that, is there any public comment either here in the room or online?
Madam
Seeing none
Chair,
in the
there are
room?
no. Oh, sorry.
Go ahead.
Apologies. There are no public comments online.
Thank you so much. With that, hearing no public comment, we will go ahead and move on to our next item, which is the consent calendar. Ms. Gamer.
Next is the proposed consent calendar. Items 6 and 7 are proposed for consent.
Thank you so much. Are there any objections to the proposed consent calendar from members of the board or the commission? No. Are there any objections from those from the public?
Madam Chair, there are no public comments online.
Okay. Is there a motion to adopt the proposed consent calendar?
Madam Chair, I move to adopt the
Okay.
proposed consent calendar.
Thank you. It's been moved. Do I have a second? And a second, if we could please have a roll call.
Yes, ma'am. Mr. Adams.
Aye.
Ms. Green Ross. Mr. Oppenheim.
Aye.
Mr. Polland.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
Great. Thank you. That motion carries. Now we will go ahead and I will turn it to Ms. Gamera to dispense with our swearing in.
Will the parties and witnesses for items 2, 3, and 4 participating remotely, please be sure that both your first and last names are listed on your Zoom window for the benefit of the court reporter. Turn on your video and unmute your microphones. And will the parties and witnesses participating in person for items 2, 3, and 4 please approach the witness table, and all parties and witnesses please rise. Beginning with item 2, on behalf of the claimants participating remotely, please state your names for the record.
Howard, Howard Guest.
And now for the Department of Finance participating remotely, please state your names for the record.
Marilyn Munoz.
And now for the State Water Resources Control Board and the Los Angeles Regional Water Quality Control Board participating in person, please state your names for the record.
Adriana Nunez.
Jennifer Fordyce. Jenny Newman.
Item 3, on behalf of the claimant, the County of Santa Clara participating in person, please state your names for the record.
Joshua Walden.
And for the Department of Finance participating remotely, please state your name for the record.
Haley Yap.
Thank you. Item 4, on behalf of the claimants participating in person, please state your names for the record.
Anya Kwan.
John Quenzer.
And for the claimants participating remotely, please state your names for the record. And for the Department of Finance participating remotely, please state your name for the record.
Marilyn Munoz.
And now for the state,
Long Wing.
apologize, thank you. And now for the State Water Resources Control Board and San Diego Regional Water Quality Control Board participating in person, please state your names for the record.
Jennifer Fordyce.
Ben Neal.
Erica Ryan.
We've not been made aware of any parties or witnesses appearing on item 5. Would anyone like to make an appearance on item 5, either in person or remotely? Thank you. And now if you'll all please rise. Do you solemnly swear or affirm that the testimony which you are about to give is true and correct based on your personal knowledge, information, and belief?
I do.
I do.
I do.
Everyone? Lovely. Please be seated. And now we ask the presenters presenting remotely for items 3 and 4 to please turn off their video and mute their microphones. And those presenting in person, please return to your seats. Next is item 2. Chief Legal Counsel Camille Shelton will please present a proposed decision on California Regional Water Quality Control Board, Los Angeles Region, order number R4-2012-0175, 13 TC01, and 13 TC02.
Good morning. These consolidated test claims allege reimbursable state-mandated activities arising from a 2012 stormwater permit adopted by the Los Angeles Regional Water Quality Control Board. This test claim presents the following disputed issues. Number 1, requirements to comply with 33 total maximum daily loads, or TMDLs, previously adopted by the Regional Board and the United States Environmental Protection Agency. A TMDL calculates the maximum amount of each pollutant that the water body can assimilate and still meet water quality standards, and assigns waste load allocations to the permittees, which in most cases requires a reduction of the discharge of a particular pollutant by the permittee. The test claim permit requires the permittees to reduce and control the discharge of the pollutants in accordance with the TMDLs and authorizes the claimants to adopt a customized watershed management plan to comply. Staff finds that the requirement to develop and submit a watershed management plan to achieve the waste load allocations contained in some of the EPA-adopted TMDLs is a reimbursable state-mandated activity from December 26, 2012 through December 17th, December 31st, 2017. For these TMDLs, if the claimants fail to develop a watershed plan, immediate compliance with the numeric effluent limitation identified in the TMDLs is required, and the failure to comply is subject to civil penalties. Permittees have fee authority sufficient as a matter of law to cover any costs beginning January 1st, 2018. The remaining TMDL requirements, including compliance with the regional board TMDLs and implementation of all the TMDLs, are not new and do not mandate a new program or higher level of service. Number 2, requirements involving the prohibition of non-stormwater discharges and conditionally exempt non-stormwater discharges. Staff finds that most of these sections do not impose new requirements when compared to prior law, and the claimants have the option of customizing their program for conditionally exempt non-stormwater discharges. Thus, the sections addressing non-stormwater discharges do not mandate a new program or higher level of service. Number 3, requirements relating to the illicit connection and discharge elimination program, the public information and participation program, the industrial and commercial facilities program, the development construction program, and the public agency activities program, all of which are designated as minimum control measure categories required by federal law. Staff finds that these sections do not mandate a new program or higher level of service. The claimants have the option to comply with the requirements stated in the permit, many of which are not new, or develop a customized watershed management program that complies with federal law. In addition, any new or increased costs to comply with the industrial and commercial facilities program and the development construction program can legally be recovered through the claimant's regulatory fee authority, and thus there are no costs mandated by the state for these programs. And number 4, requirements contained in the planning and development program, including requirements to track, enforce, and inspect new development and redevelopment post-construction best management practices. Staff finds that this section does impose new requirements that are mandated by the state. However, the cost to comply with the new requirements can legally be recovered through the claimant's regulatory fee authority, and thus there are no costs mandated by the state for these programs. I will also note that the claimant's representative, Mr. Guest, did submit late comments this morning by email to me and the water board staff. He did submit them through the Dropbox about a half an hour ago, maybe 45 minutes ago, so we haven't been able to serve the mail list, but they are working on it right now. And we did, all members did get the email forwarded, and we did send a copy to Ms. Munoz from the Department of Finance. Accordingly, staff does recommend that the commission adopt the proposed decision to partially approve this test claim for only the activity of developing the watershed management plan for the EPA adopted TMDLs that are stated in the conclusion, and authorize staff to make any technical non-substantive changes to the proposed decision following the hearing. Thank you.
Thank you. If the parties and witnesses for item 2, if you're here in the room, if you'd please come to the table. And I believe if you're online, if you'll unmute. Thank you. While they're getting settled, Mr. Guest, for the claimants, would you like to begin?
Yes, thank you. Excuse me. Good morning, Chair and members of the committee. Howard Guest on behalf of the claimants, the County of Los Angeles, the Los Angeles County Flood Control District, and 20 Los Angeles County cities. As has been described, this is a test claim seeking reimbursement for obligations and mandates imposed by a 2012 Los Angeles County Municipal Stormwater Permit. Claimants seek reimbursement for 8 different sets of activities imposed by that permit. And claimants do not waive any of their claims or arguments raised in this test claim or filings regarding the claim, but I am going to limit my argument this morning to the sections relating to the total maximum daily loads, as well as the monitoring for that, and if I have time, for the non-stormwater discharge prohibitions. In particular, the claimants submit that it is the proposed decision errs as a matter of law with respect to reimbursement for the total maximum daily obligations, load obligations. And it's also an error of fact to find that the obligations imposed by the 2012 permit were not new, that the proposed decision provides that these requirements were in essence required by a prior permit, a 2001 municipal stormwater permit, and this is an error of both law and fact. Before I begin, I just want to take a minute and talk about a little bit of terms so we can all follow the arguments. This is an area that's rife with acronyms and technical terms. You've already heard TMDLs being splayed about. So let me just take a minute. First of all, you may hear the parties refer to an MS4 or municipal stormwater permit. This is a permit that's issued under the Federal Clean Water Act. It's issued to cities and counties for the discharge of stormwater. It is not related to a sanitary sewer. Instead, what we're talking about is water that comes off the streets, collected so that there's not flooding, and then conveyed to the water bodies in Los Angeles here. That would be the ocean or the rivers. You will hear me refer to receiving waters. Receiving waters is just a fancy name for a water body. For example, in Los Angeles, the Los Angeles River is a receiving water. The San Gabriel River is a receiving water. The ocean is a receiving water. You may hear us refer to water quality standards. Again, this is just a fancy name for referring to the amount of pollutants that might be in a water body and still be able to support whatever use of that water might be. In other words, we don't live in a pristine environment. There are pollutants that are generated by the urban environment, but just because there's something in the water doesn't mean that you still can't swim in that water or fish in that water. And what water quality standards are is the amount of pollutants that can be in that water, and you could still pursue those uses. And the California Water Code recognizes that there are uses in the water and you can have levels of pollutants up to certain levels. You've heard the reference to TMDLs, which is a shorthand for total maximum daily loads. This is also really, when you come right down to it, just a number. The total maximum daily loads come from all sources, be it natural sources or human-made sources or other aerial deposition sources. And the total maximum daily load is the amount of pollutants that can be added to the water body or the receiving water body, and you still meet the water quality standard. What's very important is that a TMDL is a planning device. It is not in and of itself enforceable. It only becomes relevant when it's incorporated into a municipal stormwater permit or MS4 permit. It's the permit that's enforceable, not the TMDL. But the TMDL, as was mentioned, has waste load allocations or load allocations, and those waste load allocations are, when they are put into a permit, are enforceable. So I want to talk about the TMDLs that were put into the 2012 municipal stormwater permit. This permit incorporated 33 TMDLs. One of them is not an issue. As was referenced, some were developed by the Los Angeles Regional Water Quality Control Board. I'll refer to them as the state TMDLs. And some were developed by the United States Environmental Protection Agency, and those have been referred to as the US EPA TMDLs. The proposed decision agrees that that 30 of these TMDLs were new in the sense of not, I'm saying that they were placed in the permit for the first time. The prior permit to which the proposed decision compares the 2012 permit was adopted in 2001. And as you'll hear me address, one of the big issues is, were the 2012 TMDL permits new? Because the proposed decision basically finds that the claimants are not entitled to reimbursement for the state-issued TMDLs because there were provisions in the prior permit, which was 10 years prior, 2001, that contained provisions that required similar activities. And we submit that that's wrong, and I'll get to that in a minute. But we're dealing with, there's really no dispute that for 30 of these TMDLs, they were placed in the 2012 permit and they were not in the prior permit. So what the proposed decision provides is that in the 2001 permit, there were two different provisions that rendered these TMDLs that were included in the 2012 permit as not new. One, which was Part 3C of the 2001 permit, and the other is a section which is known as receiving water limitations. And as I mentioned, receiving waters, that's just a fancy name for the Los Angeles River, the San Gabriel River, the ocean. And the receiving water limitations in the 2001 permit provided that the permittees should not issue a discharge, or a discharge of the permittees should not cause or contribute to a violation of or exceedance of the water quality standards in a receiving water. And that's all it said. And then it had some provisions as to what to take place if that occurs, but that's basically the only standard that's provided. So I want to address why the Part 3C and why the receiving waters did not require what was required by the TMDLs, and that is why the TMDLs that are in the 2012 permit are new. And you will find this discussion with respect to Part 3C on pages 133 to 139 of the proposed decision, and the receiving water discussion follows thereafter, 139 through about 153. And let me say to the members of the commission that this particular test claim raises an issue that I think is novel for the commission, something that the commission has not decided, because as you'll hear, in fact, 3.C is not enforceable. And as you'll hear, the receiving water limitations are not lawful under the Clean Water Act. And there's really no dispute about that. But the proposed decision nevertheless says that the commission can look at these unenforceable provisions from the 2001 permit to compare to what's in the 2012 permit to determine whether it's new. And we submit that by doing something like that would be an abuse of discretion, as well as, in fact, those provisions do not require this. So let me just start to address this. Part 3C of the 2001 permit required that the permittees have what was called a stormwater quality management plan. And it anticipated the adoption of TMDLs in the future. And it said that when TMDLs are adopted or other changes occur, the permittees should amend their stormwater quality management plan to reflect that. And the proposed decision says, well, this meant that these were required under the 2001 permit, and therefore in 2012, they were not new. First of all, that's an error of fact. The TMDL, there's no evidence that the stormwater quality management plan was ever amended to include these TMDLs. And there's no evidence in the record, absolutely none, that the TMDLs were part of the stormwater quality management plan and that they were enforced against the permittees. So even though the provision referenced the possibility, the stormwater quality management plan was never amended. So just as a matter of fact, it was never included into the stormwater quality management plan. But this is also an error of law, if you should find that, because Part 3C is unenforceable. The way it is worded and what the proposed decision is providing, that all of a sudden the TMDLs become automatically included under the permit, is wrong. And it's wrong for the following reason. A permit, first of all, remember, a TMDL is not enforceable by itself. It has to be included within the permit in order to be enforceable. And the provision Part 3C said that these become part of the plan and become enforceable without any notice or hearing. But under the federal regulations and under the California Water Code, you cannot amend a NPDES permit such as this without notice and hearing. So the provision in 3C that it comes automatically included is ineffective. And in fact, the regional board has recognized and has agreed that this provision is ineffective to include any revisions to the Stormwater Quality Management Plan without a hearing before the regional board. And I forwarded to the commission this morning a judgment in a case in the litigation over that 2001 permit. And this litigation is referenced in the proposed decision, and the Stormwater Quality Management Plan is referenced on page 136 of the proposed decision. So that there's, it's already, so the litigation, and in fact, the proposed decision rests on that litigation as part of their argument. I apologize for not having submitted this earlier. I would request that the commission does accept what I forwarded this morning, which is a notice of entry of judgment in the litigation that's referenced in page 136 of the proposed decision. And in the judgment, which is attached as Exhibit B to this notice of entry of judgment, are several judgments in several related cases, including a case brought by the County of Los Angeles against the regional board and the state board. And on page 5 of that judgment, it specifically states that as to the county's first cause of action presented as issue 8 during phase 2 trial, the parties stipulated that Part 3C of the permit is interpreted to mean that revisions to the Stormwater Quality Management Plan directed by the executive officer pursuant to Part 3C are not elements of the permit, unless and until the permit is modified to incorporate them pursuant to appropriate notice and hearing. So the regional board, and this was in 2005, stipulated and agreed with the position that we're asserting now, which is Part 3C cannot be used to automatically incorporate the TMDLs into the 2001 permit. The proposed decision's reliance on that section and citing of that section for that purpose is error. It's both an error of fact and an error of law. The proposed decision goes on to say that even if you can't rely on Part 3C, the 2001 permit included a provision relating to receiving water limitations. And as I mentioned, that said, discharges shall not cause or contribute to an exceedance of a water quality standard. As both a matter of fact and as a matter of law, the commission cannot rely on that provision either for a finding that these TMDL provisions were imposed prior to the 2012 permit. First of all, it's an error of fact. Again, there's no evidence that the TMDLs or their waste load allocations or any of their elements were ever required of the claimants or permittees. The proposed decision doesn't assert that under the receiving water limitations that the TMDL waste load allocations were actually included. Instead, it asserts that, well, the receiving water limitations were similar. They were dealing with water quality standards, and therefore that was enough to impose the same obligations. However, that's an error of fact. The receiving water limitations deal with what they talk about, receiving waters, the quality of the water in the LA River or in the San Gabriel River or the ocean. TMDLs do not impose obligations regarding the receiving water limitations. TMDLs talk about what's the amount of pollutant that claimant city of X can have in the water in its pipe that then eventually gets to the receiving water. So it's a completely different obligation that's being imposed by the TMDL as a matter of fact. And let me say that it's not sufficient to just say, well, they're both trying to address the same prohibition against violations of water quality standards. In fact, that type of argument was rejected by the Court of Appeal in the case Department of Finance versus Commission on State Mandates, which was a case dealing with a stormwater permit in San Diego. And the water boards there argued that, well, if you've got a general standard like compliance with MEP or compliance with water quality standards, anything that you adopt after that is not new because you already had to comply with that standard. And the court specifically rejected that argument. It said that the application of Section 6, however, does not turn on whether underlying obligations to abate pollution remains the same. And then it went on to say, to determine whether a program imposed by the permit is new, we compare the legal requirements imposed by the new permit with those in effect before the new permit became effective. This is so even though the conditions were designed to satisfy the same standard of performance. So by just arguing that, well, you had an obligation to meet water receiving water limits, and that's a very similar or might even be the same standard as what's being required by the imposition of the TMDLs, it's not new. But in fact, the court in the Third Circuit rejected that very argument. And in fact, you can see why that's true in this particular case, because receiving water limitations could have exceedances of their water quality standards for any reasons. It could be naturally occurring. It could be algae growing. It could be bacteria or things coming from a fire that's running off. It could be, there are a lot of different ways to control and a lot of different ways to address what's going on in the receiving water. But with the TMDLs, the Los Angeles Regional Water Quality Control Board came in and said, you permittee, in your discharge, in this particular pipe, before it gets to the receiving waters, cannot have more than X amount of pollutant in it. And you have to take action to address that. Now that is different than what's in the receiving waters. So you, as the court said for the Third Circuit Court of Appeals, it might have been the same goal, but it's here you're dealing with a specific order by the water board. And so you cannot rely on just the general receiving water limitations as a matter of fact. But even more significantly, as a matter of law, this commission cannot rely on the receiving waters in the 2001 permit. It cannot do so because the United States Supreme Court in the past year has ruled that the receiving water limitation provisions like this one are unenforceable and unlawful under the Clean Water Act. And that is in the City and County of San Francisco versus EPA. And it involved receiving water limitation language just like this one. Now, nevertheless, the proposed decision is asking this commission to say, even though this provision is unlawful or unenforceable now under the 2001 permit, you should still compare the 2012 TMDLs against that unlawful, unenforceable provision. And we submit that to do so would be an abuse of discretion. The proposed decision says, well, it can't be retroactive. The 2001 permit is already finished, and you therefore should not be able to say, well, that's unlawful. But we're not asking this commission to apply the U.S. Supreme Court's decision to address the merits of the 2001 receiving water limitations. We're asking it to apply it in this case and to say that you cannot look at some unlawful provision just to justify a finding that a new provision in a later permit is not new. And we would submit that if you don't recognize the fact that the Supreme Court has ruled this unenforceable and therefore you can't use it to compare it, it's an abuse of discretion and an error of law. And I'll just say that even though I think this is a issue that this commission does not normally face, and probably it could well very be the first time, can you compare it against an unlawful provision to determine if something is new? There is an analogous situation, and it is governed by Government Code Section 17565, which specifically provides that if a local agency has been incurring costs which are subsequently mandated by the state shall reimburse the local agency for those costs incurred after the operative date of the mandate. And that's analogous to what you have here. You had a situation where even if you were going to find that the receiving water limitations imposed a similar requirement, or which we have already said we think is wrong, but if you were going to go that far, you would still find that this is something that was incurred in essence voluntarily, because it's now been determined that there was no legal obligation to do that. And so that would bring it within the intent and purview of Government Code Section 17565, which says that you should provide a reimbursement for those costs after the operative date of the mandate. And in that case, that would be the 2012 permit. So as I will say at the end, what we suggest that the commission do is not necessarily adopt this decision with respect to these TMDLs, but instead to remand it back to the commission's staff for further analysis in light of the fact that the commission cannot rely on Part 3.C and cannot rely on the receiving water limitations in the 2001 permit. And it should remand it for further analysis in that regard, unless, of course, the commission wants to go forward ahead and just find, based upon these arguments, that the claimants are entitled to reimbursement for the TMDLs in the 2012 permit. I'm not going to address the US EPA TMDL portion of the decision, other than we agree that preparing the plan is a reimbursable mandate. But of course, if all the TMDLs are reimbursable mandates, meaning the actions taken to implement them, that would be true for the US EPA TMDLs. True. Again, the proposed decision says, well, the implementation is not recoverable, but because of the 2001 permits receiving water limitations or Part 3C, and as I've indicated, that's not a correct position. That would be an abuse of discretion if you found that. The proposed decision finds that TMDL monitoring is not new. The commission should recognize that under the 2001 permit, there were only 5 monitoring stations, and they were only operated by the LA County Flood Control District. The 2012 permit provides that monitoring has to be conducted by all 82 cities that are permittees under the permit. And all the claimants now have to monitor. So this is a new requirement that's imposed upon the claimants. In addition, the monitoring is for the TMDLs, which is, again, the amount of pollutants in the particular claimant's pipes or channels, not in the receiving waters. So again, that's new, yet the proposed decision does not recognize that. And certainly, even if it wasn't new, it is a higher level of service. There's a higher level of service when the mandate increases the actual level or quality of governmental services provided. That's what the court found in San Diego Unified School District, 33 Cal 4th at 877. Here, there's no question that there's much more additional monitoring and of different analytes, different pollutants, and of different quantity. And so you're getting a increase in the actual level of quality of governmental services. So even if this was a prior mandate on the prior permit, the addition of the TMDL monitoring is a new increase in the actual level or quality of governmental services. And then I will just say in closing, with respect to the non-stormwater prohibitions, the permit added requirements that the claimants, in essence, police or monitor different entities that were discharging what they called conditionally exempt non-stormwater discharge. And the proposed decision, even though it recognizes it added these, says that this is not a new program or higher level of service. But it was an additional obligation imposed upon the claimants. And so again, it certainly was, if not new, and we think it was new, but if not new, a higher level of service. And this portion of the decision should be modified for that reason also. As I say, we're not waiving our arguments with respect to the other issues that we raised, but I wanted to specifically address the TMDLs and the TMDL monitoring and this non-stormwater prohibition because it's very clear that if the commission adopts the proposed decision, it would be an abuse of discretion. You would be using unenforceable provisions to find that this is not new. So in closing, I would ask the commission to not adopt this decision and either find that the TMDLs are reimbursable in full or alternatively to remand it back to the staff and have them further analyze the TMDLs in light of the fact that they cannot rely on Part 3C of the 2001 permit or the receiving water limitations of the 2001 permit. Thank you very much.
Thank you, Mr. Guest. We'll go ahead now and turn to Ms. Munoz from the Department of Finance. Do you have any comments?
No comments other than the Department of Finance supports staff recommendation.
Thank you, Ms. Munoz. All right, I'll go ahead now and turn to Ms. Fordyce, Ms. Newman, and Ms. Nunez for the State Water Resources Control Board and the Los Angeles Regional Water Quality Control Board. Here in the room, do you have any comments?
Did I get it right? My name is Adriana Nunez. I'm an attorney with the Water Resources Control Board, and here with me today is the Assistant Chief Counsel, Jennifer Fordyce, and Jenny Newman with the LA Water Board. Our comments are, I'll keep them brief. The water boards continue to recognize the thorough work of the Commission staff in developing the proposed decision you're considering today. We agree with the conclusions in the proposed decision to deny reimbursement and appreciate the Commission staff's revision to the proposed decision in response to our comments on the draft decision, as well as staff's analysis of the objections raised by the claimants. While we continue to disagree with the proposed conclusions that allow reimbursement, we've already stated our objections in our written comments and will not repeat those today. To the extent that the late comments submitted by claimants, if the Commission is inclined to hear them, we do not think that they warrant any changes to the decision, given that there's analysis in the briefing that says even without 3C, the conclusions would stay the same. Thank you.
Thank you. Any other comments from other?
No, but we're available to answer questions as needed.
Thank you. Very much appreciate it. Are there any, I'm going to bring it back to the Commission and staff, but are there any other public comments on this item? Don't see
Madam Chair,
any
there are no online public comments. Apologies.
That's all right. Thank you. And I don't see any in the room. So let me go ahead now and bring it back here to the commission. I don't know if staff would like to also comment. Let me bring it to the commission first. If there's additional questions, then I'll have staff respond. Are there questions from the commission on the proposed decision? Mr. Paulin.
Well, yeah, I would like to hear staff's response to the contentions made by the petitioner.
Okay.
Absolutely. Oh, it is not. Oh, no, it's
No,
it is.
it's on.
Yeah, is it not?
Are you not hearing me? Okay, I wasn't close enough.
Mr. Paulin will go closer to the mic from now on.
All right.
Madam Chair,
Yes.
I would second that request just for
So
the.
let me do that. Let's go ahead and take this back to staff for their response, and then we can bring it back to commission members for further conversation and questions.
Okay, thank you. There is a lot to unpack there. First, let me just indicate that the prior permit is a quasi-judicial decision. It is final and binding on the commission. The courts have held with respect to our decisions and other quasi-judicial decisions that once they're final, then they're binding, and we don't have the authority to overturn them. So your job is to interpret the language of the prior permit. You cannot find that any of the provisions are not enforceable. That's true for both Part 3C and for the receiving water limitations. On the receiving water limitations, just let me jump to that. Mr. Guest did refer to the City and County of San Francisco case. That's a 2025 Supreme Court case. And it did analyze the receiving water limitation language in that permit. The courts have found, though, that a Supreme Court decision only goes to decisions that are still open for review. And this 2001 decision is final. We have no way to go back and to overturn that language. So while the City and County of San Francisco decision may impact other interpretations of permits that are still open on review, I don't see it. It's not an abuse of discretion. We don't have the authority to go back and rule that something is not valid from 2001. The 2001 permit was litigated so much and upheld by different levels of court. It is a decision that we have to follow. With respect to Part 3C, so the language there in the permit directed the permittees to modify their stormwater quality management plans when the TMDLs became effective. The regional board TMDLs became effective. When you look back at the record, it is talking about the regional board TMDLs, and the record, including workshop agendas and fact sheets, indicated that they wouldn't have to reopen the permit to do that because there was enough notice and hearing during the TMDL process. The TMDLs are orders, they're resolutions. They come with implementation plans that were adopted as part of the resolutions. And in fact, if you go to page, if you go to PDF page 139, hard page 136, there's a list of 9 regional board TMDLs where the final compliance deadline had passed before the test claim permit was adopted. So I'm not understanding if Mr. Guest is suggesting that they didn't have to comply with those TMDLs. They were required by law to comply with those TMDLs before the test claim permit was even adopted. So, that they had to comply some way to do that. It is interesting about the late information that he has provided. It does say that the regional board and the claimants in that particular case interpreted the provision of 3C a little differently than we've interpreted it here. I don't think that really matters for your purposes because there are alternative grounds. The alternative grounds, which are consistent with every other stormwater permit test claim the commission has adopted, is that the compliance with the TMDLs, the activities to comply are just simply not new. Under prior law, the prior permit and under federal law required that a claimant propose or a permittee propose their own management program. And under the prior permit, they had to comply with the water quality standards of the receiving water limitations and discharge prohibitions. That said, your discharges may not cause or contribute to a violation of water quality standards. The water quality standards are in the basin plan, and in this case, it's a 1994 basin plan. The basin plan has narrative effluent limits and numeric effluent limits. It also governs the California Toxics Rule, which has numeric limits for certain priority toxics like bacteria. They were required to comply with those under the prior permit. And under the prior permit, they could design their own program and meet those water quality standards. That same thing is true here. The TMDL, the only difference between having a TMDL and not having a TMDL is that the TMDL sets the waste load allocation so that each discharger knows what they need to do to, how much they need to reduce to meet those same water quality standards. The water quality standards have not changed. And the activities, if they decide to change them, that's up to them. They are proposing those activities. They're proposing those plans to comply with the same existing water quality standards. So compliance with the TMDLs is just not new, and it does not mandate a new program or higher level of service in this case. The same is true for the monitoring. I will say with respect to monitoring, that federal law requires monitoring sufficient to determine whether or not you're meeting water quality standards. And under the prior permit, they had to increase their monitoring and increase their best management practices and control measures if their discharges were not meeting water quality standards and there were exceedances determined in monitoring. So they weren't set at any particular level. Also, each permittee, even though the flood control district was responsible for the countywide monitoring program, each permittee under the prior permit was responsible for their own discharges. In addition, the TMDLs, when you look at those resolutions, they did identify responsible agencies, and they're not limited to the flood control district. In fact, many of those resolutions require that monitoring plans be approved, and they had to be approved by the responsible agencies for that particular TMDL. Again, as I mentioned earlier, page 139 PDF lists 9 TMDLs where the final compliance deadline occurred before the adoption of the test claim permit. The test claim permit says that, well, if you haven't complied, you're required to comply with those immediately because you're late. So this is not new. And those findings are consistent with what the commission found in 09 TCO3, 10 TC11, 11 TCO3. There's no difference in analysis. In fact, I copied it. So the language is the same.
Thank you. Mr. Poland?
Yeah, just follow-up question. As I understand the claimant's argument, the 2001 permit related to maximum, contaminant loads in a large body of water, and the subsequent permit governed maximum contaminant loads in a smaller body of water that flowed into a large body of water, and therefore he said they're different. So that's how I understand his argument. Am I misunderstanding his argument, or? Well,
you can ask Mr. Guest what he's arguing, but that's not correct. So even before the prior permit in 1996 and 1998, there were numerous water bodies, receiving water bodies in the LA area that were impaired. Under federal law, the regional board had to designate those as impaired water bodies. Under the law, when you have an impaired water body, you have to establish TMDLs. There was litigation brought on by nonprofit suits against EPA and the regional board because they were taking a long time to adopt the TMDL. So they came to a consent decree saying you have until this date to adopt these 33 TMDLs. So the 2001 permit was most certainly aware and required them to comply with water quality standards in the same receiving waters. The receiving waters don't change. What he's suggesting is when you take a measurement to determine if you're exceeding water quality standards, you're taking that measurement at the point of the outfall, which might be right before the stage of the water body, the receiving water. But the whole point of the Clean Water Act is to protect the receiving water. So, you have pollutants flowing through and then out to the receiving water. So they're trying to prevent it at an earlier stage. But that's no different than what's going on now. That's always been the case. The same receiving waters have always been there. And the point of both permits and all permits have been to protect those same receiving waters. So we're not talking about different waters.
Mr. Powell?
Does the claimant, excuse me, does the claimant contend that the Clean Water Act does not create an enforceable obligation with respect to receiving waters?
Are you asking Mr.
I'm asking the claimant.
Mr. Guest, are you available to respond? Mr. Guest?
I think you have to unmute.
You have to
Mr.
unmute,
Guest.
sir.
Okay, so the question is whether there's an obligation under the Clean Water Act with respect to the receiving waters or large bodies of water. And you'll laugh because I'm going to give you a lawyerly response. But first of all, let's start out by saying the goal of the Federal Clean Water Act is to make all the waters in the United States fishable, swimmable, cleanable, clean. So in that sense, it is directed to it. The way it operates, though, in this context, is that what happens is permits are issued with respect to the discharge of pollutants by individual entities. And those permits define what the permittee's legal obligations are. And those are called NPDES permits. And in this case, a municipal stormwater permit is a type of NPDES permit. An NPDES permit might be issued to an industrial facility that discharges into the water, might be issued to somebody else. In this case, it was issued to municipalities that are collecting stormwater. They're actually not generating their own this pollution, but they're collecting the water and the pollution that's coming off our streets and funneling it to the water body. So if you ask, does the Clean Water Act want to encourage the remediation of pollution in the large water bodies? Yes. How does it do it? It imposes certain obligations under specific permits. And what we are doing here today is trying to determine whether the obligations that were imposed under the 2012 permit are new, or whether these were the same obligations that were imposed under the 2001 permit. Now, let me say, though, going to the general question of, well, if you're focusing on the requirement to clean up, for lack of a better word, the water in the large water body, the Court of Appeal in the of the Third Circuit in California answered the question of, well, just because you're trying to reach the same goal or it's the same prohibition doesn't mean that a new or different directed activity is not a state mandate. In fact, the Third Circuit found that even though you're going towards the same standard or same goal, when the regional board comes in and gives you a specific direction, like here, on your discharges in your pipe that are eventually going to go in the LA River, you can only have so much of a pollutant. That's a mandate. That's a mandate, and the proposed decision doesn't deny that in a sense. But what they're trying to just say is well, there was something else in the 2001 permit that makes this not new. And as for the reasons we'd articulated, it is new. While I'm here, I want to just answer the other commissioners' questions as to whether we are saying that there's a difference between the large receiving water body and the smaller discharges that are coming out of the municipal stormwater system. And yes, we are making that distinction. And that's because the TMDLs make that distinction. Mr. Chair, I've got some other points that I want to say in response to commission staff's arguments when it's appropriate.
Thank you. Let me come back to the commission members first, and then we'll come back to you, Mr. Guest, in a moment. Are there other comments or questions from commissioners? Yes,
believe
Mr. Powell.
Staff Counsel has a response to that. Is that correct?
On one point, I wanted to clarify that the Court of Appeal decision he's referring to, Department of Finance versus Commission on State Mandates, it's a little misleading, his argument, because the argument that the court was addressing was the Water Board's general argument that no NPDES permit could ever be reimbursable because the permits are establishing this, are working under the same standard as federal law. So they were trying to make the argument that everything was federally mandated. In that case, there was no dispute about the activities and whether they were new. So that analysis of the court does not apply here. In fact, the court did correctly say that when you are determining whether an activity is new, you compare the activity to the law in effect immediately before the requirement of that activity. So you do look at the prior permit, you do look at federal law, and this is no different than what we've done on the last several test claim decisions. So I don't agree with him on that point. And on the receiving waters, if you look at the prior permit, there's a large discussion in the findings of the prior permit and in the fact or the provisions that everything is addressing receiving waters. Each body of water was impaired. Each body of water has now a TMDL for whatever the pollutant was, whether it's trash, bacteria, PCB, whatever the issue was. So each body has the TMDL and each body of water is protected under the Clean Water Act. And that is the whole point of the NPDES permit system, is to protect those same water bodies.
Thank you. Further questions or comments from Commission? Mr. Pollan?
Yeah, I guess I'm having an arithmetic problem and I may not be following anybody's argument correctly, and that's why. But let's assume there's a receiving body and a contributing body, or it wouldn't be a body, contributing conveyance. Say the TMDL established in 2001 for the receiving body is 10, 10 units of whatever. Then let's assume the contributing body conveys 5 units to the receiving body on a regular basis. However, the contributing body does not cause the receiving body to exceed that 10. So the 5 conveyed by the contributing body does not cause the receiving body to exceed its TMDL. Did the 2012, let me strike that. Let me start the hypo over. The receiving body also conveys 10 units, but because it contributes proportionally smaller volume to the receiving body never exceeds 10. Did the 2012 permit say you must look at the contributing conveyance and determine whether or not it exceeds 10? Or is the focus always been on or in 2001 was the focus also on the contributing body too?
I'm not sure I'm following you because the TMDL waste load allocations were set in other orders, not in this test claim permit. The test claim permit just says comply with the TMDLs. Adopt the same waste load allocations, didn't make any change whatsoever. So both the prior permit and the test claim permit are dealing with the same water bodies. They are dealing with the same stormwater and non-stormwater discharges from these permittees. The only difference, as we've indicated with the TMDL, is now the permittees know how much they've been determined to be a discharger, a point source that is discharging and contributing to the exceedance of whatever the pollutant is in the water body. And now they know exactly how much they have to reduce in line with other dischargers. I mean, in some of these have, Caltrans or industrial dischargers that are also point sources and also have to reduce their loads to meet the water quality standards of the water. So under the prior permit, they had a duty to continually monitor their receiving waters and their outfalls to determine if their discharge was contributing to an exceedance of water quality standards. The same is true now. So the activities have not changed. They, under the prior permit, could design their program to determine how they best could reduce that discharge, and that is still true today under this test claim permit.
All right, thank you.
Does that answer your question? Ish.
Ish.
Okay. Other questions? Okay. So if I can just piggyback a little bit and clarify, the question at hand has nothing to do with the load amounts changing. There's no change in the activity that any of the individuals who are discharging into the receiving waters had to make under this new permit that's different than the 2001 permit as it relates to the levels in which they were discharging or how they address that. Or, I mean, I think part of the question is to Mr. Pollan's comment is that, you know, and to your point, that these receiving waters, which is the ultimate goal of keeping those, that's what we want clean. That's under the federal piece, that there are multiple entities that are contributing to the ultimate load that ends up in the receiving waters, right? And that process has not changed between the 2001 and 2012?
Well, I think the water board should probably participate in this discussion. They're the experts on this better than I. But I will say that, you know, when they're going through the adoption of the TMDL, it's a scientific process. Certainly, you know, it takes a while to determine exactly who the point source discharges are. It takes a while to, you know, mathematically determine whose loads, how much loads are causing, you know, the exceedances. But again, those were adopted in prior orders. They do know that, you know, in all of those cases, the NPDES stormwater permittees were source dischargers contributing to the pollutant discharge. And they knew that before. So the only thing that is changing is that they now know how much they have to reduce. They have an exact waste load number, but the activities are not different. The activities are still what they had to do before. You still have to reduce the discharge to the maximum extent practicable and meet water quality standards. They can propose their program under the prior permit, and they can propose their program now.
Okay, thank you. Does Water Resources have any comments or additional input?
We're happy to provide more information on how the TMDLs themselves work, if that's helpful.
Would commissioners like that information? Okay, I think we're okay. I just have one last, I just want to go back to the statement around the San Francisco case, and I just want to make sure I'm understanding staff's interpretation of that, is that because of the date in which that decision came down, which I think you said was 2025, is that correct?
Correct.
That the argument can't be made that it then has an implication on a decision for the 2012 permit. Is that we can't go
The
back?
2001.
I'm sorry, 2001 permit. We can't
Yes.
go back.
There's Supreme Court decisions that talk about an impact of a Supreme Court decision, and it only goes back to those decisions that are still open on
Okay.
review.
Okay.
And the 2001 case has been upheld by the courts a long time ago.
Okay.
So it's a final quasi judicial decision. There's no way we can go back and determine it to be unlawful.
Okay, thank you. Other comments or questions? Yes, Mr. Powell.
I have one question, and it's something we haven't discussed yet. It's about fee authority. And so even if we were to accept that this was a mandate, claimants could potentially, and there is the case made by staff, that they still would have fee authority to cover any costs. And so it's not a mandate.
No, not for, so that only, you know, if the commission or a court were to approve the compliance with the TMDLs in any fashion, you know, they were required to start under this permit at the effective date of the permit, which was December 28th, 2012. They would have the authority under the law to assess property-related fees. But under Proposition 218, back then, they would have had to get the voters' approval first. The courts have held under Prop 218 that if the voters have to approve a fee authority first, then for purposes of mandates law, the local government does not have the legal authority because you have to have pre-approval first. Back in 2017 and effective January 1, 2018, Senate Bill 231 was adopted, and if the parties are disputing the meaning of 231, but we're required by law to presume it's constitutional, but it did define storm water to fall now within the exclusion to not have to get voter approval. They just have to have a vote, allow for a voter protest. And the courts in Paradise Irrigation District, that was the name of the case, found that when voter protest was required, then the cities and counties still have the legal authority to impose the fee, despite the possibility of a protest. And so under that case, 17556D is valid and says that there are no costs mandated by the state. So circling back to this, if the TMDLs in any fashion were approved as state mandated new program or higher level of service, there would be, based on the evidence in the record, costs mandated by the state up until December 31st, 2017. Beginning January 1, 2018, they have the legal authority to impose a fee.
And that's why there is that period of time with the Howard Jarvis, I think it was,
Yes.
in 2012, where a section of this does carve out a state mandated fee
Oh, right,
for a
but we're
small
fine.
section of this.
Right, but this decision is finding that those requirements are not imposing a state mandated new program or higher level of service, so I don't even get there. On the regional board TMDLs, the EPA TMDLs, the ones that are listed under, this decision finds that they have practical compulsion to comply with developing a watershed management plan for those. So to the extent, I don't know how long it took them to develop a watershed management plan and have it adopted, but this decision finds that that is a state mandated new program, higher level of service. They do, their record does support that they do have costs exceeding $1,000 to develop that watershed management program. If it took them longer than December 31st, 2017, and they incurred any costs after that date, they would not, those costs would not be eligible because they have fee authority.
But going forward, 2018 until another source says otherwise.
Right.
They would have fee authority.
Yes.
And do claimants dispute, I mean, since they dispute
Oh, all parties.
constitutionality,
Yeah.
but we,
All parties are disputing the
You don't
effect of
determine that.
yes,
thankfully.
yeah.
But just to clarify though, on the planning and land development program piece, while we found that was a new requirement, there is
That's
fee.
regulatory fee authority.
Regulatory fee.
So that is a
Okay.
different type of fee authority where they can impose it on developers. I mean, it's a different part of the Constitution. They have that authority and under the police power. So regulatory fee authority, you don't have voters' approval required at all, and you have the authority. And the courts have upheld that, both with development and with inspection of commercial and industrial facilities. There's fee authority.
Okay, thank you. Any other comments or questions from the commission? Okay. This is an action item. We do have a staff recommendation on the item. Of course, as well, the commission does have the ability to put forward another motion. I do believe Mr. Guest did want to, had a couple of final comments. So Mr. Guest, I will go ahead and allow you to provide some final comments before we bring it back to the commission for action. I just ask if you could keep those brief, please.
Thank you very much. I will keep them brief, and I just want to address 3 points. First of all, with respect to the application of the U.S. Supreme Court case, we're asking for that to be applied in this case. We're not asking this commission to address the 2001 permit and find as a finding relating to that permit that it's that for some reason that should be now changed. We're saying that in this case, the commission should recognize that this provision was unenforceable and unlawful. And therefore, you should not go forward and say an unenforceable, unlawful provision should be used to find that a requirement is not new. The first time that there was an enforceable provision was when the TMDLs were adopted into the permit in 2012. Because the receiving water limitations, this commission can say, look, we're not going to use something that the Supreme Court has said is unlawful to say that it's not new. I think this is an issue that the commission has never decided before. And as a matter of not only equity and fairness, but as a matter of law, it's an abuse of discretion to find an unlawful provision to be a basis for finding that a obligation is not new. So that's the first thing. We're saying we're applying in this proceeding, not prior proceedings. Secondly, I believe that the effect of the TMDL was not accurately described. Council indicated that the TMDLs were enforceable orders when they were adopted. The proposed decision recognizes that that's not the case. The proposed decision itself recognizes that it's not an enforceable obligation until it's put into the permit. And that's why they had the arguments relating to Part 3C is relevant. And in the proposed decision on page 110, and your PDF numbers may be a little different, but on page 110 of the proposed decision, they talk about what a TMDL is. And they say that it's a planning document. And they say that, and they quote from a case, and they say, TMDLs established under Section 303D1 of the Clean Water Act function primarily as planning devices and are not self-executing. That's what the proposed decision itself recognizes, and that is in fact the law. The TMDL imposes no obligation on any party for any reason until it's put into an NPDES permit. Okay, that's the law. And so to base your decision on some other understanding would be an error of law. And then finally, let me just say with respect to the fee authority, I think our position actually was correctly stated. We disagree with the interpretations that are provided on SB 231 and the date of that we cannot recover or that we would have fee authority from January 1st going forward. But we recognize that the commission cannot make that decision. And we recognize, why the commission has said what it said. But we don't agree that provision is constitutional. That's for another day.
Thank you, Mr. Guest. Okay. I'm going to bring it back to the commission. This is an action item. As I mentioned, we have staff recommendation and the will and pleasure of the body to make an alternative motion if that would be where they'd like to be. So let me open it up. Is there a motion?
I'll move to approve the staff recommendation.
It's been
And I thank council for the clarification.
moved by Mr. Oppenheim. Is there a second on the staff recommendation motion? Okay, seconded by Mr. Powell. Will you please have a roll call?
Mr. Adams,
Aye.
Ms. Green Ross,
Aye.
Mr. Oppenheim,
Aye.
Mr. Polland,
Aye.
Ms. Peralt,
Aye.
Mr. Powell.
Aye.
Thank you. That motion carries. Thank you so much to everybody for being here and spending the time to move through this item. We are now, oh, go ahead.
We now ask the presenters participating remotely for item 2 to please turn off their video and mute their microphones, and those presenting in person to please return to your seats. Before we proceed to item 3, Madam Chair, the court reporter would require a break at this time.
That's fine. It is 11:20. Is looking at the court reporter. Five minutes. Okay. You need 10 minutes. Okay. We'll go ahead and reconvene at 11:30. Thank you. Thank you so much. Okay, we're going to go ahead and bring the commission meeting back to order. And our next item is item 3, Ms. Gummer.
Thank you, Madam Chair. We now ask the presenters participating remotely for item 3 to please turn on their video and unmute their microphones. And for those presenting in person, to please come to the table. Commission Counsel Anna Berich will please present a proposed decision on internet websites and email addresses 24 TC04.
Good morning. This test claim is regarding Government Code Section 50034 as added by the 2023 Test Claim Statute. The Test Claim Statute requires cities and counties to ensure their internet websites for use by the public and public email addresses for their employees utilize either a .gov first-level domain name or .ca.gov second-level domain name by January 1st, 2029, and to ensure that any internet websites with non-compliant domain names they continue to maintain after the deadline redirect users to a website with a compliant domain name. Standard definitions of the word website, as well as the rules of statutory construction, support that the legislature intended its requirements for internet websites for use by the public to extend to component files that make up a website, including web pages, web applications, or other related resources. Staff finds that the test claim statute imposes a reimbursable state-mandated program pursuant to Article 13B, Section 6 of the California Constitution, beginning January 1st, 2024, for the one-time activities to 1. Ensure that the internet website used by the public, including any web pages, web applications, or other related resources within the website, utilizes either a .gov top-level domain name or a .ca.gov second-level domain name by January 1st, 2029. 2. Ensure any websites, including any web pages, web applications, or other related resources within the website with a non-compliant domain name the city or county continues to maintain after January 1st, 2029, redirects users to a website with a compliant domain name. And 3, ensure that each public email address provided for the city's or county's employees utilizes a .gov or .ca.gov domain name by January 1st, 2029. Staff recommends that the Commission adopt the proposed decision to approve the test claim and authorize staff to make any technical, non-substantive changes to the proposed decision following the hearing. Thank you.
Thank you so much. Okay. Parties and witnesses, as I call you, if you please just state your name for the record. Mr. Walden, for the claimant, would you like to begin?
Now is this on? Okay. Good morning. Thank you. Joshua Walden on behalf of the claimant, Santa Clara County. The county agrees with the commission staff's conclusions and would respectfully ask the commission to adopt the proposed decision. I have no further comments prepared, but I'd be happy to answer any questions.
Thank you so much, Mr. Walden. Ms. Yap from the Department of Finance, do you have any additional comments?
Finance has no comments on this matter. Thank you.
Thank you so much. Okay, are there any public comments on this item? Seeing none in the room, are there any online?
Madam Chair, there are no public comments online.
Okay, I will go ahead and bring it back to the commission at this time. Are there any comments or questions on the item from commissioners? Okay, seeing none, is there a motion to adopt staff recommendation or otherwise?
Madam Chair, I would so move.
Okay, moved by Mr. Adams, excuse me. Is there a second?
I will second the motion.
Seconded by Mr. Oppenheim. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Green Ross.
Aye.
Mr. Oppenheim.
Aye.
Mr. Polland.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
Thank you so much. That motion carries. So we will now move on to item 4.
We now ask the presenters participating remotely for item 3 to please turn off their video, mute their microphones, and those presenting in person, please return to your seats. Next is item 4. We now ask the presenters participating remotely for item 4 to please turn on their videos and unmute their microphones, and those presenting in person to please come to the table. Chief Legal Counsel Camille Shelton will please present a proposed decision and parameters and guidelines on San Diego Regional Water Quality Control Board Order R9-2007-000107 TC09R.
Good morning. These proposed parameters and guidelines address a 2007 stormwater permit issued by the San Diego Regional Water Quality Control Board. The Commission partially approved the test claim in 2010. and the decision was litigated until 2022, resulting in a third district court of appeal decision approving the commission's decision, except for the court's denial of one activity based on the fee authority exception. The test claim approved reimbursement for the following activities: reporting on street sweeping and conveyance system cleaning, certain requirements under the educational program, watershed activities and collaboration on the watershed urban runoff management program, specified requirements under the regional urban runoff management program, program effectiveness assessment, the one-time long-term effectiveness assessment, and all permittee collaboration to promote consistency with the jurisdictional urban runoff management and the watershed urban runoff management programs, and the one-time requirement to amend a permittee agreement to include a few additional requirements. The proposed parameters and guidelines raise several disputed issues, which are identified in the chart in the executive summary. These issues include the following. Number one, staff finds that the San Diego County Regional Airport Authority and the San Diego Unified Port District are not eligible to claim reimbursement under Article 13B, Section 6, because their revenues are not proceeds of taxes subject to the appropriations limit. Number two, the period of reimbursement is from January 24, 2007 until December 31, 2017. Beginning January 1, 2018, the claimants have authority to impose property-related stormwater fees for all the activities. Number three, the scope of the reimbursable activities is consistent with the Commission's test claim decision. A few reasonably necessary activities are recommended for approval based on evidence in the record as one-time and ongoing activities. Number four, the Commission has no authority to approve reimbursement for interest and legal and expert costs incurred during the mandates process as requested by the claimants. Number five, the claimants have proposed reasonable reimbursement methodologies in the form of unit costs and formulas based on estimated or average costs for each group of reimbursable activities in lieu of filing detailed documentation of actual costs subject to the audit of the State Controller's Office. The claimant's original proposal would result in reimbursement over $252 million. The claimants have since revised and reduced some of their unit cost proposals. The RRM findings cannot be viewed like a settlement agreement. Instead, the adoption of an RRM must be based on substantial evidence in the record to support the conclusion that the proposed RRMs consider the variation in costs among local government claimants, balance accuracy with simplicity, and ensure that the unit cost proposals reasonably reimburse all eligible claimants for the actual costs mandated by the state. Staff finds that while a few of the revised proposed formulas are reasonable, some proposals are not limited to the mandated activities, and there is not substantial evidence in the record that the proposed unit costs, either total shared costs or cost per activity, reasonably represents the actual cost mandated by the state for all eligible claimants for the higher levels of service activities the Commission approved for reimbursement. Staff recommends that the Commission deny the RRM proposals. Number six, offsetting revenues, including stormwater fees recovered and used on the program, are identified in the parameters and guidelines consistent with the Commission's test claim decision. Accordingly, staff recommends that the Commission adopt the proposed decision and parameters and guidelines and authorize staff to make any technical non-substantive changes to the proposed decision and parameters and guidelines following the hearing. Thank you.
Thank you. Okay, so if the parties, again, and just a reminder, parties and witnesses, if you'll please state your name for the record. Mr. Deek, Ms. Kwan, and Mr. Quenzer. I might have said that wrong. I'm so sorry. For the claimants, would you like to begin?
So, okay, perfect. Thank you. Just I wanted to let everybody know that Mr. Deek will know, oh, sorry, Anya Kwan. Thank you. That Mr. Deek will no longer be joining us today. So it'll just be me and John Quenzer. Commissioners, thank you for giving us the opportunity today to orally comment on the test claim related to 7TC09R, which relates to the San Diego Regional NPDES Permit Order R9-2007-001. I'm here today to comment on behalf of the Port of San Diego, the San Diego International Airport, and the 19 cities and counties that are covered under this order. I'm going to start my comments for the port and the airport, and then after that, John Quenzer and I will then provide additional comments that relate to the municipal claimants. Just a quick question, would you like to stop and allow comments after that, or do you just want me to keep going?
Go ahead and present completely, and then we'll come back for full comments. Thank you.
Perfect. The crux of the issue for the Port of San Diego and the San Diego International Airport is that a local government is not the same as a local agency. Article 13B, Section 6 specifically refers to a local government and mandates that the state reimburse a local government when the state legislature or state agency mandates that local government to implement a new program of or increased level of service. Local government is defined in the California Constitution under Article 13B, Section 8D as any city, county, city and county, school district, special district, authority, or political subdivision within the state. As you can hear from that definition, the definition is very broad and would include the port and the airport in that definition, and therefore they should be eligible for reimbursement under Article 13B, Section 6, as they fall under the definition of local government under Article 13B, Section 8D. Instead of using the definition of local government, the parameters and guidelines rejects the port and airport's claim for reimbursement on the definition based on the definition of local agency. Because Article 13B, Section 6 refers to local government and not local agency, the definition for local government is the one that should be used. And the associated case law and statutes and implementing statutes for the definition of local agency should not be considered when determining whether or not Article 13B, Section 6 should apply to the port and the airport. If the Commission has decided that they should use the definition for local agency, we have an additional issue with relying on Government Code Section 7901E as the definition for local agency. Article 13B, Section 6 is specifically implemented by Government Code Sections 17500 through 17630. Within these government code sections, Government Code Section 17518 has a definition of local agency. Article 13B, in general, the entire article, is implemented by Government Code Sections 7900 through 7914. Within those government code sections, there is a definition of local agency in Government Code Section 7901E. Because Section 17518 specifically implements only Article 13B, Section 6, this is considered to be the specific definition of local agency, while the definition of local agency in 7901E is the general definition because it applies to the entire Article 13B. I'm just going to make it a little clear that, Government Code Section 17518 is a broader definition than the Government Code Section 7901E. So the specific definition, 17518, is more broad in general than the definition in 7901E, which is the general definition. So it's a little bit confusing, but I just wanted to make that clear. Because Section 17518 is the specific definition that only implements Article 13B, Section 6, that is the definition that should be used and not the definition that governs the entire Article 13B. By using the definition that only implements Article 13B and not specifically Article 13B, Section 6, the interpretation renders Government Code Section 17518 useless. As stated previously, Government Code Section 7901E is more specific than Government Code Section 17518. So if the definition of 7901E is applied to Article 13B, Section 6, then therefore there's no place and no use for the definition given in Government Code 17518 that implements only Article 13B, Section 6. Because there is a conflict that then prevents Government Code Section 17518 from having a use, this is an impermissible way to interpret the provisions that then interpret our Constitution. Finding otherwise would make the Port of San Diego and San Diego International Airport an exception to Article 13B, Section 6, general purpose of reimbursing state mandates, an exception that the legislature did not intend. Therefore, the Port of San Diego and San Diego International Airport should be entitled to reimbursement for their activities performed under the applicable MS4 permit. I'm going to switch gears, and now I'm going to talk about the municipal claimants and their requests. So John and I, on behalf of the 19 cities and counties within San Diego, are going to focus our comments on a few discrete issues. The municipal claimants want to make it clear that we are not withdrawing or waiving any of the arguments provided in our previous comment letters that are not specifically mentioned today. As was talked about in the other unfunded mandates relating to a regional stormwater issue, we are not waiving the comments related to SB 231, but we're not going to discuss them here. So first, I'm going to provide a brief summary of the case, history of the case, and provide background on reasonable reimbursement methodologies, or RRMs. John's then going to explain the RRMs, but we'll focus on a few RRMs that we believe additional detail is needed based on the last round of comments that we received. I will then finish up the discussion to address some of the fairness considerations that were raised in the last round of comments for the in the last draft of the parameters and guidelines. The permittees were subject to Order R9-2007-001 issued by the Regional Board in 2007. The permittees filed their test claim to the state mandates in 2008. The Commission adopted its initial test claim in March 26, 2010. This decision was challenged via writ petition that was then ultimately resolved through two Court of Appeals decisions, one in 2017 and another one in 2022. This decision in 2022 was then brought to the California Supreme Court, but the Supreme Court denied the petition and did not hear it. The two Court of Appeals decisions did not substantially confirm the initial test claim decision in March 2010, so there was not a large change from that initial draft. As you can hear from that timeline, this process took years, and so now we're talking about reimbursement for work that was done 18 or 19 years ago. Just as a side note, I wanted to say that we do really appreciate the time that staff has taken to provide comments on our RRM, and that, the last round where you're explained some of the, accepting some of the formulas and questioning the unit cost was really helpful in our analysis. So as stated in the previous comment letters, an RRM is a formula for reimbursing local agencies for costs mandated by the state. Reimbursement through an RRM is intended to be an approximation of costs and does not represent actual costs. Because it's an approximation of costs, RRM is not intended to be perfect justice. Instead, it's intended to serve as rough justice as found by the Commission's previous determinations accepting an RRM. In the matter of habitual truants, the Commission adopted an RRM for reimbursement based on a unit cost per habitually truant student. In this adoption, the Commission specifically found that an approximation of local costs was sufficient to support an RRM. It says, an RRM is meant to be an approximation of local costs and need not precisely reimburse every dollar expended on the program. As such, the Commission has previously acknowledged that RRMs can be adopted to provide imperfect but reasonable reimbursement. With that background, I will turn it to John.
All right. So just, I guess, for everyone to clarify, my role in this is...
Can you state your name for the record again?
Sorry, John Quenzer. So my role is to provide technical support. I work on municipal program support in the San Diego region. I've done so since 2004. So my role was to look at the data provided by the different claimants, to analyze it, and to propose the reasonable reimbursement methodologies, or RRMs. So before we get into a couple of them to talk in a little bit more detail, broadly speaking, there's two different kinds of RRMs that we have proposed. One is based on work that was done by work groups or groups of the claimant agencies. And in those cases, typically one agency will either perform the work or have the work performed by a consultant where they're managing the contract for that work. So the billing will be through that agency, and then it's distributed through a cost share agreement or a memorandum of understanding. So in that type of formula, we do have in the record the expenditure data, and we can tell you what the amount of money is. The other type of formula is a unit cost formula, and the typical format of that is there's a unit cost, how much does it cost every time that you do that activity, times a quantity, how many times did you do the activity. So what we're proposing for those kind of formulas is only the unit cost part of it. We're not making any statements about how many, what the quantity is right now. As staff had mentioned earlier, in one of our earlier submittals, we did have some quantities in there, but that's not what we're proposing right now. So if the commission was to approve any of the unit cost RRMs, the next step would be for the municipal claimants to submit documentation of what is the quantity, and that's how they would calculate the amount that they would be due. So for example, one of the ones that we'll talk about is cleaning out a storm drain or a catch basin. What we're proposing on that one is to establish what is the unit cost, which is about $89. That doesn't tell you how much is potentially reimbursable, because the next step would be for the claimants to say, well, how many storm drains did we clean? If they clean 10, for example, then 89 times 10 is 890. That would be the number, but they would need to provide documentation of how do those 10 storm drain cleanings meet the criteria for reimbursable storm drain cleanings. So with that out of the way, I wanted to speak first to a couple of the shared cost category RMs. One is for the long-term effectiveness assessment, and the other one is for some educational costs. In both of those, our understanding of the commission's comments was that they were based on budgets rather than actual expenditures. So for the first one, for the long-term effectiveness assessment, we agree. It was the case that what we submitted was based on budget, but we do have in the record what the actual expenditures are. And so we're proposing to change what we're asking for on that one to be based on the actual expenditure. And I'll try to go through this slowly because we'll be citing some dollar amounts and pages in the record. So if I need to repeat anything, just let me know. The overall total that's based on the expenditures would be $232,673.30. That's based on the following items. So the first one, which is the majority, is an invoice from a consultant, Weston Solutions, that had a total amount billed for task 2, which was long-term effectiveness assessment, for a total of $219,621.25. That invoice begins on volume 13, page 11,982. The next item would be that the County of San Diego, as the contract manager, also assessed a 5% contract management fee on that amount. 5% of that amount would be $10,981.06. This one is based on a couple places in the record. So both are volume 13. One is in an expenditure report from the Fiscal Reporting and Assessment Work Group, which is on page 11,979 of volume 13. The other one is on an expenditure report from the Monitoring and Assessment Work Group, or excuse me, the Regional Monitoring Work Group, which is on volume 13 again, pages 12,102 through 12,103. And I would like to clarify on those that, just without going too far into the details, the the budget for the long-term effectiveness assessment was shared between two different work groups. And the way that the monitoring work group had it in their budget, it was combined with some other activities that are not reimbursable. So that's why we're proposing to use the invoice amount, which has a clear line item that just says it's for the long-term effectiveness assessment. And then from those expenditure reports from the work groups, you can see that the 5% management fee was consistently charged. The other two items are the County of San Diego reported some staff costs in an expenditure workbook that is on page 11,978 of volume 13. That amounts to $1,083.88. The last item is the City of Santee also reported staff costs to collect and analyze data for the long-term effectiveness assessment of $987.11. That is also from volume 13, page 12,111. Do I need to repeat any of that? No? Okay. The other shared cost item was for some educational activities done through an education work group. And I wanted to point out on that in table 11 of my most recent declaration, the values that are in there are based on expenditure records, and the citations to the locations in the record all are correctly citing the expenditure amounts. It is true that sometimes on those same pages cited, there will be both a budget and an expenditure amount. But when that was the case, we used the expenditure amount. So for example, on page 12,305 of volume 13, there was a budgeted amount of $73,665 for producing some educational materials, but the expenditure was $57,298, and we used the expended amount, not the full budget, to reflect what was actually spent, not what was budgeted. The other note about the education activities is that we were careful to only select the line items from those expenditure records that relate to education of the general public. We did not include line items that might have been read to mean education targeted at, let's say, the development industry or industrial dischargers, which had been marked as not a reimbursable activity. Then I have a couple comments also about unit cost, reasonable reimbursement methodologies. So the first one that I would like to say is that in general, the way we develop these is by looking at the median cost of the underlying data sets. It was sometimes the case that there were outliers, especially on the higher end of the data set. So if we would have taken the average would be higher than the median, and we felt that the median was a more representative and conservative value. So one example of that is the jurisdiction watershed activities. This proposed unit cost was based on a data set of 71 reported watershed activities. Those were reported by the municipal claimants in annual reports that were signed and certified by applicable people within their agencies and submitted to the San Diego Water Board as required by the stormwater permit. And this includes activities from all of the 8 watersheds that are fully within San Diego County. And what we got from looking at that was that, yes, there were some activities that were pretty expensive, but using the median value, we get $5,000 per activity. Using the average, we would have about $8,164. So again, we feel that given the spatial distribution of the activities and that we have over 70 of them, that's a good enough data set to be representative. We do understand that the proposed value we have may be less than what some agencies actually spent, but we still feel it's reasonably representative. Similarly, if we move to the last thing that I'm going to talk about, which is there's a group of unit cost RRMs that were originally based on some surveys performed of the claimant agencies in about 2011. And the commission had noted that that's not a source of data that we can use for a variety of reasons. So what we still included those, but we also included an alternative in our last submittal. And it's that alternative that we're wanting to propose. The alternative is based on signed declarations from a subset of the municipal claimants. So I'll just use one as an example. This applies to catch basin cleaning and then reporting on conveyance cleaning and street sweeping, but I'll just talk about the catch basin or storm drain cleaning portion of it. So on that one, there were 5 of the 19 claimants that submitted a signed declaration. Those claimants ranged from larger agencies like the City of Chula Vista, which is one of the larger agencies in the region, to smaller agencies like the City of Solana Beach, which is one of the smallest cities in the region. They included agencies from the north and the south and the east side of the county. So in my opinion, 5 out of 19, and given that there is the variation in size and geography, is enough to be a representative data set. Within that data set, 3 of the agencies had cost per cleaning a storm drain that was about the same, about $88 or $89 per drain cleaned. The other 2 had somewhat higher values, but again, because we're using the median, we get a value of about $89. It is true that this may be a little bit less than what some of the agencies actually would have paid to clean their storm drains. But again, we feel like it's reasonably representative, and the agencies, the claimants, have directed us that it is their direction to propose that unit cost, and that is something they're willing to accept. So Anya's going to talk a little bit more about that aspect of it.
So John has talked substantively about 2 categories of RMs, those based on actual costs and those where we have an RRM or a unit cost that has been proposed. I'm really going to talk about some of the fairness considerations that the commission staff raised in their last draft of the parameters and guidelines. In a settlement agreement, I understand this is not one, there is a provision called the good faith settlement determination, which considers whether or not a settlement is brought in good faith. And then if it is, then it acknowledges that somebody may propose a settlement for reasons besides maximizing financial return. So here, the claimants are proposing this RRM. In hiring BBK and DMAX to create this RRM and propose it to you, they acknowledged and understood that it's not going to be a perfect reimbursement of their costs, but instead of an approximation based on this RRM, supported by the data that they're hoping you'll accept to receive their reimbursement. So as such, given that the claimants have hired us to provide the RRM, and we understand that not everyone's going to be able to maximize financial recovery based with this RRM is accepted, the claimants believe that the RRM should not be rejected just because not all the claimants will receive their maximum amount based on the nature of the RRM itself. The municipal claimants thank the commission for the time to present on portions of the RRM to try to explain why we believe they are fair and reasonable. The claimants wish to reiterate that we have not withdrawn or waived any of the previous arguments made in the comment letters. However, we wish to specifically augment the arguments related to certain RRMs. Specifically, the claimants wish to clarify that the RRMs for the residential educational activities and the long-term effectiveness assessment were based on actual costs that were provided in the record. Additionally, the claimants wish to provide clarification on what data supported the unit costs for the RRMs for reporting on street sweeping and conveyance system cleaning, and jurisdictional water activities. The municipal claimants appreciate the Commission's time in considering these additional comments. The municipal claimants ideally would love if the RMs were accepted, but understand that if we need to go back and work with Commission staff to create better unit costs or flesh out data, we would be happy and willing to do so. Thank you.
Thank you. Let me go ahead now and turn to Ms. Munoz and Mr. Nguyen from the Department of Finance. Do you have any additional comments?
The Department of Finance concurs with staff recommendation in this matter, and we are also available to respond to any questions.
Thank you so much. I think so. We'll now move to Ms. Fordyce and Ms. Ryan. And is Mr. Neal online? Or oh, there he is. Okay. For the State Water Resources Control Board and San Diego Regional Water Quality Control Board, do you have any comments?
Yes, we do.
Okay, thank you. Go ahead.
So good afternoon now, barely, commissioners and staff. My name is Jennifer Fordyce. Yes, sure. Is that better? Better? No? It's okay. I better hold this. All right. My name is Jennifer Fordyce. I'm with the State Water Board's Office of Chief Counsel. I am joined by Erica Ryan next to me and Ben Neal behind me because we just didn't have a chair. And with the San Diego Regional Water Board. And we're going to keep our comments fairly brief. So we wanted to first express appreciation of the thoughtful and exhaustive work of Commission staff in developing the proposed decision you're considering today. I think, as most of you know, we don't always see eye to eye on the various test claim matters, but here we definitely do. We concur with Commission staff careful analysis and conclusion that the claimants' proposed reasonable reimbursement methodologies, or RRMs, must be denied as they are overbroad or not supported by evidence, not limited to the activities previously found by this Commission to be subject to reimbursement, and do not represent eligible costs. In addition to other numerous flaws, the claimant's proposed RRM would unreasonably reimburse claimants for a period of up to 425 days from the permit effective date, regardless of whether they actually performed any mandated activities during this period. The proposed RRMs would result in significant overpayment to some claimants, which simply cannot occur. These flaws underscore that the alternative RRM approach does not work here, and frankly, it may not work for any similar test claim for MS4 permitting that involves multiple co-permittees, each with different governance, population size, budgeting process, costs, and offsetting revenues for MS4 related mandate activities, where there's multiple eligible costs and multiple timeframes. As these are not consistent across all claimants, it does not lend itself to a single methodology or unit cost per mandated activity. The proposed one-size-fits-all RR approach to reimbursement should be denied here. We support and urge the Commission to adopt the proposed decision before you. Claimants must be required to submit claims based only on actual costs and with supporting source documentation for the actual performance of state mandated activities that the Commission previously found reimbursable. The claimants have already spent the money to perform these activities and should be able to submit documentation backing up those costs. The claimant's contention that it is unreasonable to expect them to have retained actual cost information to support reimbursement is not a legal or recognized basis to approve an RRM. And to address 2 points raised before, one is I think it's clear this is not a settlement, so there's no good faith owed to what's been submitted. And two, to the extent that the claimants are trying to seek additional time to work with the Commission on fixing some of these major flaws, we would object to that. There's been multiple opportunities to fix this along the way. We've raised these issues and they've been aware of these issues for some time. So we don't think any further opportunities should be provided. With that, we appreciate the opportunity to speak today and we're available to answer any questions. Thank you.
Thank you. I appreciate that. Moving to public comment. Is there any public comment on this item? I see none in the room. Is there any online?
Madam Chair, there are no public comments online.
Okay, thank you. I'm going to go ahead and bring it back to staff if staff has any additional comments.
Just a couple things on the reasonable reimbursement methodology. The decision does identify examples of where the commission did approve an RRM unit cost. They were examples where it was all of the claimants basically had to do one thing, like counting widgets. And so the range of costs for all the different claimants were not that wide. It was, there was some variation in costs. We did consider an approximation of all the costs, but it wasn't a wide variation of costs. And here we have really wide variation of costs depending on the activities that we're talking about. So that was kind of a primary concern, and I sort of agree. This is just not a case that the commission would typically adopt an RRM, especially with the amount. I don't ever think that the commission's ever adopted a statewide cost estimate of that amount. So that was one of the concerns. On the eligible claimant issue with the airport authority and the port district, the problem with the claimant's arguments is that they're not referring to case law. Case law talks about the whole point of Article 13B, Section 6 is because of the tax and spend limitations in the Constitution. And, the Supreme Court has said, and ties directly, the purpose of reimbursement is directly tied to the appropriations limit. And it's only dealing with costs that are recovered solely from tax revenues. The city of El Monte case said you can't accept the benefit of a non-tax revenue that's exempt from the spending limits and also claim reimbursement for those costs. That's why we have 17556D that says that if you're getting money, you have authority from non-tax sources like fees and assessments, then you're not entitled to reimbursement. This argument comes up periodically. It's come up over the last 30 years. We've been in court on it number of times and have won. So it is a situation where you have to be able to show that you have the authority to levy taxes, which the airport authority does not, and that you had the authority to levy taxes and actually levy those taxes in the 77-78 fiscal year. And the port district, while it has authority to levy taxes, their financial statements show that they have not levied taxes since 1970. So they have not spent any tax revenue on these programs. I'm happy to answer any questions on any particular RRM. I did go through each one. It was difficult to understand the records, probably, 150,000 pages of things. So a lot of it was the survey data, which is really hearsay. And the commission has found that before, that's hearsay and not reliable. One, because I don't know who it is that's signing it. I don't know where they're getting their information. Is the information an estimate? Is it based on actual costs? What direction were they given? They don't identify the sources or who they are. So it's just not reliable. And there's been no foundation laid for those surveys. But I'm happy to answer any questions that you might have.
Thank you. Let me go ahead now and bring it back to the commission. Do commissioners have any questions? Mr. Adams.
Just a comment. While I appreciate the place for RRM, it seems to me the key word there is reasonable. And again, as a member of local government, we would love to see these kind of things when they're appropriate, but just picking out one thing on page 28, I see a range of $138 versus $67,000 for street sweeping to try and use a middle or a median or an average. Obviously, somebody's going to get way under reimbursed and somebody's going to get way over reimbursed. So I appreciate, again, both sides of this, but that's tough to swallow. Thanks.
Thank you. Others? Mr. Pollan?
Yes, thanks. I've got a question for the claimant. No, I've got a question for the claimant. Where do the airport and ports revenues come from?
One second. Commission, I don't believe I have written about this, and so I'm not 100% sure I can answer that question at this time. My apologies.
All right, no further questions for me.
Okay. Any other questions from commissioners? Okay. All right. Seeing none, this is an action item. Is there a motion to adopt staff recommendation or an alternative?
I move to adopt staff recommendation.
Moved by Ms. Green. Is there a second?
I'll second.
Seconded by Mr. Oppenheim. If we could please have a roll call.
Mr. Adams,
Aye.
Ms. Green Ross,
Aye.
Mr. Oppenheim,
Aye.
Mr. Polland,
Aye.
Ms. Peralt,
Aye.
Mr. Powell.
Aye.
Thank you so much. That motion carries. And I think we are now on to item number 5.
We now ask the presenters participating remotely for item 4 to please turn off their video and mute their microphones. And those presenting in person, please return to your seats. Item 5. Senior Commission Counsel Laura Doherty will please present a proposed decision and parameters and guidelines on elections ballot label 24 TC 01.
Good afternoon. These parameters and guidelines address state mandated activities arising from Elections Code Section 9051, as amended by the test claim statute, which requires counties to print supporter and opponent lists in the ballot label for statewide measures, including in other languages when required by state or federal law, and instructed to do so by the Secretary of State, following the Attorney General's condensed ballot title and summary. No substantive comments were filed on the draft expedited parameters and guidelines, nor on the proposed decision and parameters and guidelines. On each, the controller recommended no changes. Staff recommends that the Commission adopt the proposed decision and parameters and guidelines with the reimbursement period beginning July 1st, 2023, and authorize staff to make any technical, non-substantive changes following the hearing. Thank you.
Thank you so much. Okay, I don't believe we received any parties and witnesses for item 5, if I'm correct. But before I move on, are there any parties or witnesses who would like to appear on this item who have arrived after swearing in? I see none in the room.
There are none online, Madam Chair.
Okay, thank you so much. With that, is there any public comment on this item? I see none in the room. Is there any online?
Madam Chair, there are no online public comments.
Great, thank you so much. Then let me bring it back to the commission. Are there any comments or questions from commissioners on this item? Okay, seeing none, this is an action item. Is there a motion to approve or to adopt the staff recommendation?
I'll move to adopt the staff recommendation.
Moved by Mr. Oppenheim. Is there a second? Second by Ms. Green Ross. If we could please have a roll call.
Mr. Adams,
Aye.
Ms. Green Ross,
Aye.
Mr. Oppenheim,
Aye.
Mr. Polland,
Aye.
Ms. Peralt,
Aye.
Mr. Powell.
Thank you so much. That motion carries. I think that brings us now to, we already took up the consent calendar, so I think that brings us to item 8, Ms. Gimmer.
Yes, ma'am. Next, Program Analyst Jill McGee will please present item 8, a legislative update.
Good morning. The following are the legislative updates since the last time the Commission met. First, SB 414, School Accountability, Office of the Education Inspector General, School Financial and Performance Audits, Charter School Authorization, Oversight, Funding, Operations and Networks, Flex-Based Instruction, Local Educational Agency Contracting. SB 414 was introduced by Senator Ashby. Among other amendments to the Education Code regarding charter schools, this bill amends Government Code Section 17518 and adds charter school to the definition of local agency as follows. Local agency means any city, county, special district, authority, charter school, or other political subdivision of the state. On September 3rd, 2025, this bill was read a second time and ordered to a third reading. On September 9th, 2025, this bill was suspended per Joint Rule 61A13, was read a third time and amended, and was ordered to a third reading. On September 13th, 2025, this bill was suspended per Joint Rule 61A14 and 51A4, was read a third time, passed, and was ordered to the Senate with concurrence in Assembly amendments pending that were concurred in, and this bill was ordered to engrossing and enrolling. On September 23rd, 2025, this bill was enrolled and presented to the governor at 2 p.m. On October 13th, 2025, this bill was vetoed by the governor and remains in the Senate with consideration of the governor's veto pending. Next, AB 964, Commission on State Mandates, State Mandates. AB 964 was introduced by Assemblymember Hadwick. This bill amends Government Code Section 17558.5. This bill would require the controller to notify the claimant in writing within 30 days of any adjustment that results from an audit or review, and now requires the controller to allow a local agency or school district, at the sole discretion of the local agency or school district, to offset any reduced reimbursement as prescribed or to remit funds to the controller. There has been no new action on this bill. Next, AB 1452, State Mandates, Claims. AB 1452 was introduced by Assemblymember Ta. This bill amends Government Code Section 17564. This bill would change the minimum claim amount that requires the state to reimburse a local government from $1,000 to $800. There has been no new action on this bill. Next, SB 470, Bagley-Keene Open Meeting Act, teleconferencing. SB 470 was introduced by Senator Laird. This bill now amends Government Code Sections 11123.2 and 11123.5. The act authorizes an additional alternative set of provisions under which a state body may hold a meeting by teleconference subject to specified requirements. Existing law repeals these provisions on January 1st, 2026. This bill now repeals these provisions on January 1st, 2030. On October 1st, 2025, this bill was approved by the governor and was chaptered by the Secretary of State as Statutes 2025, Chapter 222. Finally, AB 395, Holidays. AB 395 was introduced by Assemblymember Gabrielle. This bill amends Government Code Section 11131, the Bagley-Keene Open Meeting Act. Among other things, this bill would require that a state agency shall make every reasonable effort to avoid conducting any meeting, conference, or other function on a date for which the state agency knows or has reason to know that members of the public would be unable to participate or be present due to the ritual observance of a religious, cultural, or ancestral holiday. There has been no new action on this bill. Staff will continue to monitor legislation for bills that impact the mandates process. Thank you.
Thank you, Jill. Next, Chief Legal Counsel Camille Shelton will please present item 9, Chief Legal Counsel report.
Good morning. The commission does not have any litigation pending, and so I have nothing new to report. Thank you.
Thank you, Camille. All right, and now on to item 10, the Executive Director's report. I've got 3 information items. First, the Commission's 40th year. With this December hearing, the Commission completes its 40th year. On January 1st, 1985, the Commission was established to render sound quasi-judicial decisions regarding the application of Article 13B, Section 6, to alleged unfunded state mandates and to provide an effective means of resolving disputes over the existence of state-mandated local programs. We acknowledge the dedication and service of our Commission members and the staff members who have served the Commission for the past 40 years. Item 2, workload. As of December 1st, there are 37 pending test claims, 32 of which are regarding stormwater NPDES permits. There are 3 parameters and guidelines, 5 statewide cost estimates, and 1 incorrect reduction claim pending. Third, tentative agenda items. This is just a reminder to please check the tentative agenda items on the Executive Director's Report or the pending caseload documents on the Commission's website, which are updated at least bi-monthly to see when something is tentatively set for hearing. Draft proposed decisions for all test claims and IRC matters are issued for review and comment at least 8 weeks prior to the hearing date, and a proposed decision approximately 2 weeks before the hearing. Madam Chair, that's all I have.
Thank you so much. We are going to move into closed session, but before I do so, this is our last meeting of the year, and I did want to just take a moment to thank staff. It has, I know, been an exhaustive year of a lot of work, and I just wanted to thank all of you and wish you hopefully some happy holidays and a little bit of a break. So, but with that, we are going to go ahead and move into closed session. The Commission will meet in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The Commission will also confer on personnel matters pursuant to Government Code Section 11126A1, and we will reconvene in open session in approximately 10 minutes. Thank you so much.
Okay, now I have to join you.
All right, on my plans.
Oh, it did. Okay. All right. Okay, thank you. Welcome back. We are going to reconvene into open session. The commission met in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission also conferred on personnel matters pursuant to Government Code Section 11126A1. With no further business to discuss, I will go ahead and entertain a motion to adjourn.
So moved.
Moved by Mr. Oppenheim, seconded by Ms. Green Ross. And it has been moved and seconded. So if you'll please call the roll, Ms. Skimmer.
Yes, ma'am. Mr. Adams.
Aye.
Ms. Green Ross.
Aye.
Mr. Oppenheim.
Aye.
Mr. Polland.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
Thank you. That motion carries and the meeting is adjourned at 12:56. Thank you so much, everybody.